Ladies and gentlemen, my name is Igor LEKIC, and I am the advisor to the Ombudsman of Croatia. I wish to greet Mr. Jurica Malčić, the Ombudsman. Since we are short of time, I have shortened the speech I have prepared for today, which is in fact the struggle against discrimination in the Croatian context, primarily through legislation. I apologize to the interpreters who have a copy of my presentation. I hope they'll be able to follow. I wish to say that the Croatian constitution guarantees equality to all citizens as the highest value, and everyone in Croatia has the same rights and freedoms regardless of race, color, sex, language, religion, political or other convictions, national or social origins, property, birth, education, social status, or other characteristics. Everyone is equal before the law. The rights and freedoms guaranteed by the Constitution and the entire legal order may be limited exclusively by law in order to protect the freedoms and rights of others and the legal order, public morals and health, but under the condition that every limitation must be proportional to the nature of the need for limitation in each individual case. In Croatia, there is an anti-discrimination law which entered into force in 2009. However, even before that, there was legislation guaranteeing protection against discrimination. So there were some 30 pieces of legislation to protect from discrimination. The most important of these were the constitutional law on the rights of national minorities, the Labor Act, the Act on Gender Equality, the Act on same-sex partnerships, the law on civil servants, the penal code, the law on service in the armed forces of the Republic of Croatia, and the law on free legal aid. All these acts rely on international documents, the Declaration on Human Rights, the Convention on removal of all kinds of racial discrimination, and the Convention to prevent all forms of discrimination against women. However, in Croatia, there was a need to put in place a single umbrella act, legal act, which protects against discrimination, and this protection is broader than the European directive, and its application can be much broader than is the case with European legislation. This is an expression of political will to really suppress discrimination in all its forms, but it opens up a number of dilemmas in the implementation of our legislation. This is a challenge also with respect to the existing European jurisprudence. I'm referring primarily to the Court of Human Rights, European Court of Human Rights, and the European Court of Justice. The Act defines discrimination, places the burden of proof in harmony with the European legislation, makes it possible to institute a lawsuit and joint lawsuit for groups of vulnerable citizens, and puts in place a central body for the suppression of discrimination. In spite of the broadened base of forms of discrimination, there is no hierarchy of kinds of discrimination prescribed in this law. All forms of discrimination are banned, but there are some cases where putting someone in an unfavorable position is not considered discrimination, and these are exceptions. The law applies to all legal and physical persons, especially in areas of housing, education, healthcare, and culture, but in all areas of life. The Ombudsman is duty-bound to prosecute all kinds of discrimination with the agreement of the victim. The plenipotentiary of the Croatian Parliament is in charge of is really the Ombudsman is the plenipotentiary of the Croatian Parliament in the area of discrimination, and is the central body in charge of suppressing discrimination. He can take action against any governmental body at any level, as well as legal entities and physical persons, investigates all complaints of discrimination, provided that no court proceedings have started. He may file motions to indict. He may work together with the public prosecutor, or he may institute a lawsuit on behalf of a group of people. The Ombudsman also informs the public and the Croatian Parliament of any cases of discrimination, gives proposals and recommendations to the Croatian government in this respect. As I have already said, the Ombudsman reports on all instances of discrimination to the Croatian Parliament. Allow me to tell you very briefly about this tool available to the Ombudsman. In the report for 2011, the Ombudsman pointed out, inter alia, that the especially vulnerable situation of members of the Roma minority was evident in Croatia, and that members of ethnic minorities, especially Roma, were most often the victims of hate speech. Roma are classified as one of the most vulnerable social groups, and in the action plan and national program for Roma, the plan is to empower them and to enable them to participate on an equal footing in all areas of life in Croatia, especially in the area of education. In this report, we describe the situation, which is something new in Croatia, and which comes within our purview under the law. The Ombudsman, when contacted by an NGO or the Center of Peace Studies, and this case actually refers to two young Roma women who were unable to do their work practice part of their secondary education in a particular company. The court case was complicated. It was very emotional for the victims, especially one of the young women who was still attending the school and who was victimized in the school because of the court case. However, in February this year, the first instance proceedings were completed, and the court ruled in favor of the plaintiff. I wish to point out that In our report to the Croatian Parliament for 2009, we said that regulating status issues for Roma was one of the burning issues for Roma in the Republic of Croatia today. Regulating their status is the basis for their enjoyment of all the other rights prescribed by law, and a large number of Roma in spite of having spent a long time on the territory of Croatia, have not been registered in any register administrative document in Croatia. In 2009, the Ombudsman joined in the project of entitled Social Inclusion Support to Marginalized Communities. The role of the Ombudsman's office in the project was to provide direct assistance in registering Roma, their entry into the register, birth registers, issuing personal documents, providing them information of all the rights they have based on their status. The project activities were aimed at increasing the social inclusion of Roma, the full enjoyment of civil rights for Roma in Croatia, but also protection of members of the Roma community from possible discrimination, especially those displaced during the war, and enabling them to access free legal aid, especially when it comes to obtaining personal documents and enjoying basic human and civil rights. In our work, we noticed the fact that the status of Roma is not regulated often causes a subjective feeling of discrimination among them, and this is expressed in their conviction that their applications are rejected for the sole purpose of preventing them from enjoying all the other rights they would be able to enjoy if they were given residence or citizenship or some sort of status. That is why pointing always to the decisions of the Constitutional Court of Croatia when it comes to regulating citizenship for persons who are in a difficult situation due to transition. The Ombudsman's office has worked on these issues. We have also referred to the Orsush case in the court in Strasbourg when indirect discrimination was established in the case of a group of pupils from Međimurje who were segregated in so-called Roma classes in Međimurje. I wish to point out that in the spring there was a case where on the 1st of May this year, in a place called Škabrnja in Croatia, a protest rally was held because a family which was perceived as a Roma family was evicted, and the Ombudsman expressed public concern over this fact. It was said that in Croatia, in the 21st century, the sort of things that were heard at this rally should not be heard. Discrimination is banned by the Croatian constitution, numerous international treaties, and other legislation. Discrimination also occurs when a gathering is not violent, but hate speech is used. And this can be a basis for a lawsuit based on the Anti-Discrimination Act, but also penal proceedings if the crime of hate speech has been committed. As the central body in charge of preventing discrimination in the Republic of Croatia, we asked the police to submit a report to us on the event and on the actions they have undertaken. We also warned the mayor and the municipal authorities on the need to suppress such events. And we can say that the police submitted a motion to indict to the prosecutor against the persons responsible for these actions, and the proceedings are now underway. We still have a lot to do in the area of protecting human rights and preventing discrimination. But the new legislation is a significant step forward in this direction. Also, Croatia has harmonized its legislation with the LEKIC in this area. Thank you for your attention.